The federal government is answering calls to strengthen Canada's bail system. New legislation will make it harder for those accused of certain offences to be released on bail by expanding the use of reverse onus. That means those accused of a crime have to show why they should be released instead of prosecutors having to prove why they should stay behind bars. Reverse onus would be expanded to apply to certain firearm and intimate partner violence offences. The measures face criticism from opposition parties today.
Randall McKenzie, who is the accused killer of Constable Perchella, already had to overcome the policy of, already had to follow through and prove the onus on him to be released. And he achieved that. So he was released, even though there was an onus on him to prove that he should be. In other words, he would have been released by this regime, the catch and release regime the Liberals are reinforcing today.
David Lametti is Canada's Minister of Justice and Attorney General. Minister, thanks for coming in.
Pleasure to be here.
Premiers and police have been asking for an expanded reverse onus here provisions when it comes to bail. Do you think you've met the bar that they were looking for?
I think we have. If you look at what the premiers asked for in their letter to the Prime Minister in January, we've actually done that and added a bit more. It reflects what we discussed in March with the provincial and territorial ministers of justice and public safety ministers. We agreed on the general direction that we had to go, and we had an idea of the specific provisions, and this reflects that. They've begun to invest too, which was part of, I think, part of the general consensus was that we had to work together and that it would take some criminal code reform, but would also take further investments in the system of the administration of bail. As well as federal investments in things like guns and gangs, and we've done that too.
They were calling this a catch and release bail system. The fact that you've met and even exceeded some of their requests, is that not an acknowledgement that there was a component of catch and release or an element of that in the bail system in Canada?
I don't accept that characterization. I think that Bill C-75 was a good piece of legislation. Canada has fundamentally sound, a fundamentally sound bail system. It is a charter right. And you're innocent until proven guilty under our legal system. They're bedrock foundational points in our legal system. We have to respect that. We didn't do anything in Bill C-75, I think, that merits that catch and release phrase, but we have focused on repeat violent offenders here. And we've focused on a number of offences, in particular with weapons. And I think that's what the premiers were looking for and my counterparts, and that's what we've done. So
C-75 is the legislation that made changes to the law that an individual's background had to be considered when assessing bail because of overrepresentation in the criminal justice system. What happens when the provisions of C-75 collide with these new measures today? Which has paramountcy in the judge's decision-making process?
Well, they don't collide, and even prior to C-75, the priority is still public safety. That's always the absolute priority, even with consideration of an Indigenous person's background. That didn't change in Bill C-75, and it doesn't change now. But what we have done with respect to particular offences, so repeat violent offenders, as well as offences with weapons, including knives and including bear spray, is to say you've got to show, the default provision is you won't get bail. Again, we're protecting public safety. You've got to show why you should get bail. A person's background will still be considered there. The context will still be considered. That's why we have judges. That's why we have justices of the peace hearing bail. Police officers also have a measure of discretion prior to the person getting to bail court. But all of that remains the same, but what we're doing is making it more difficult in those additional areas.
Right, so there has been praise for this today, statements from the Canadian Police Association, the Police Association of Ontario, Toronto Police Association, all praising this, and they weighed in heavily on this debate because of the police shootings, going back really to the OPP officer, Greg Perchella. I'm sure you heard what Pierre Poilievre said today, his criticism that these changes would not have kept the person accused of killing Officer Perchella in jail because that was a reverse onus case, but the Indigenous background of this person was paramount in what the judge decided in releasing him. What's your response to Mr. Poilievre's criticism?
Well, Mr. Poilievre wants everything in criminal law to reduce down to a silly slogan, frankly. And what we're doing is the opposite of that. We're basing it on evidence. We're basing it on collaboration with experts, with police officers, with provincial and territorial counterparts, because we all have a role in making the system better. We're giving discretion to judges and justices of the peace in our system. That's the strength of our system. What the bill does today is it gives further encadrement or framing to the decision maker. It asks the decision maker to jump through certain hoops with respect to reverse onuses and take certain things into account with respect to community. And that's important to do. It will lead, we think, to better results. That's why we've done it.
In this particular case, though, how would it have changed things in terms of this person being released?
Well, again, I'm not going to go back and talk about a specific case, but it sends a clear message that public safety is paramount here, and where there is a risk of recidivism of a violent offender, that person should not be released on bail.
So the reverse onus provision, according to the technical briefing we got today as journalists, says it creates a reverse onus for an accused person charged with a serious offense involving violence and the use of a weapon where the accused was previously convicted of an offense of the same criteria within the past 5 years.
That's right.
Why only 5 years? Why not lifetime? Why not 10? I mean, how did you land on that time frame?
Well, again, the idea here is repeat violent offenders, and so repeating the gist of the critique, if you will, or the gist of the expression of desire in this case by provincial premiers and provincial attorneys generals was getting these people that were continually in front of the system, and the 5 years reflects that. As well as the criteria that there be a history of violence there. We think we've hit that right. Again, we don't want to go too far. It is a charter right. It also has the potential to clog up the bail courts, again, which we don't want to do. So we've tried to strike a balance here. We think we have, and we'll monitor it closely to make sure that we've gotten it right.
On that balance, the clogging up of the bail courts, if more people are incarcerated because of the reverse onus as they await trial, you have capacity issues in provincial correctional facilities. I mean, how do you address that, the knock-on effect of these changes at that level?
Well, again, we are hoping that this applies to a small number of cases, but these are repeat cases, and so this really is what the message is that we are getting, which is it's a small number of people who are continuing in front of the system. We're hoping that we're targeting them, so we're hoping that those capacity issues won't be problematic. On the other hand, we'll be working with provinces to monitor the situation, and we'll course correct. The bill itself says we have to look at it again in 5 years, but we certainly work closely with provinces and territories with respect to the administration of the bail system, and we'll continue to do that.
What's a small number? Do you have metrics on that? Like how many repeat violent offenders are we talking about that go through the court system every year in this country?
Well, metrics is a problem, and data is a problem. The provinces at the March meeting have all taken on the responsibility, the engagement to provide more data and get better data and share more data. Statistics Canada is also doing the same thing, or beginning to do the same thing. There are data gaps. So we're hoping to build a better data picture as we move forward so that we have a better idea on the metrics.
Okay, Justice Minister David Lametti, thanks for your time.
Thank you.